everybody. Mr. Constitution, Douglas V. Gibbs, douglasvgibbs.com. And, we've been seeing a lot of interesting things going on with the Trump presidency, and we've seen a lot of pushback, the resistance against President Trump. And what we've been seeing is a lot of court cases out of it. And what's interesting is, first of all, and some of the courts have recognized this, the groups that are going after Trump have no standing. And so, real quick, just for clearing the floor here, so make sure we all understand. Standing is basically a three-legged stool. There must be an injury. The person being charged or indicted or, well, in this case, prosecuted against must be connected to that injury. And then if the prosecution wins, then there must be a partial or full remedy or resolution to that injury. And so all three of those must be met in order to have standing. And typically, a lot of these groups don't have a direct connection to the injury when they launch these lawsuits. They find these anti-Constitution, anti-Trump judges, and then they rule. And a lot of it's been unconstitutional. So I would like to go over it. And what we've seen is, and I'll put up here on your screen here, but basically the left-wing political machine has been employing the courts to obstruct President Trump's agenda, and there's been 6 things that they've mainly attacked, and I'm going to go through those 6 things, and generally, if the federal courts have the constitutional authority to go after the U.S. president the way they're doing it. So the things that's been attacked is federal spending, federal workforce, birthright citizenship, DOGE access, the auditing access to federal and all that jazz, federal law enforcement and the federal prisons. Now, the federal workforce, federal law enforcement, and federal prisons are pretty much the same answer for all 3, so I'm going to lump them together. So after I get into the courts versus the president, whether or not the courts have the authority in the first place, after that, then we'll go through those 4 things, and I'll be sure to put the images up on there so you know what I'm talking about. All right, that all said, let's kind of talk about the president versus the courts in the first place. So the question that I get, first of all, is can the courts be used to go after the president the way they're doing it? And really what it's coming down to is this. The president of the United States is vested with the authority or the power of the executive office. Vested with the executive power. The executive power is vested in the president, as it says in Article 2. Article 1, all legislative powers herein granted shall be vested in a Congress. In Article 3, all judicial powers shall be vested in the Supreme Court and inferior courts, which the Congress may institute or make. So really it comes down to, can the courts interfere with or dictate to how the executive carries out his executive powers? Ultimately, that's the question. Now, first of all, you'll notice I use the word vested here. And the word vested in each of those articles, first sentence of each of those first three articles of the Constitution, means that the powers are exclusionary and irrevocable. Exclusionary, only that branch has those powers, and irrevocable, they can't just give them away. So that's our first idea. So then what that is, that's separation of powers. Judicial branch, you stay in your lane. Legislative branch, you stay in your lane. President, you stay in your lane. Legislative branch, you create law, you modify law, and you repeal law. If the president likes them, he can sign them. If he doesn't like them, but you believe it needs to be done, and he vetoes it, if 2/3 of each house says, no, we're going forward anyway, you can do that. You have the power of the law. If you have enough votes, you can even go over the president's head and make sure something becomes a law. The president's job is to execute the law. So while he does sign laws, bills into law, once again, they go over his head. So that's not his total power. His total power is the execution of law. Article 2 says that he shall faithfully execute the laws of the Union. So his job is to execute laws that are on the books. So the question is, when it comes to these items that we're talking about, is he executing the law? Is he not executing the law? Or is he acting in an unconstitutional manner? And then, if he is acting in an unconstitutional manner, who has the authority to say, hey, you can't do that? Hey, we need to take a look, checks and balances, Then finally got the judicial branch. Judicial branch, they apply the law to the cases they hear. But do they have the authority to, take law actions or, go after executive orders? So they're there to apply the law. Can they apply the law to executive orders? And if they can, what can they do about it? Can they dictate to the president how he runs his executive branch? And I'll get into a little bit more detail on what the president is expected to do. So, that said, first of all, let's go with, can the courts enforce against the president their rulings? And I'm going to use two pieces of precedent, because in the Constitution, the way the Constitution is written, authorities are granted. Now, we kind of have an exception with the Bill of Rights in the sense that the federal government is told you cannot make law regarding our rights, our natural rights. So it tells the federal government what it cannot do. Don't touch our natural rights. But aside from that, first 7 articles and basically anything else in the amendments as originally intended, if the federal government is going to have an authority, it has to be granted. It's called the enumeration doctrine, and that doctrine is supported by the 10th Amendment, which basically which tells you that the powers are delegated by the Constitution to the U.S. government, the federal government, and that if something is not delegated to the federal government and it's not prohibited to the states, then it's a state authority. So enumeration doctrine, there are powers delegated. If it's not delegated and the states aren't told that they can't do it, then it's a state authority. It's a state power. That's the Constitution in a nutshell. It's the enumeration doctrine in a nutshell. So, nowhere in the Constitution grants to the courts the authority to dictate or enforce against another branch. Well, Doug, judicial review. Judicial review is not in the Constitution. First of all. Second of all, judicial review originally only applied to laws. Executive orders are not laws. Executive orders are the execution of laws or the execution of the executive branch. Executive orders are also instructions to those that are in the executive branch from the president on how to carry out what his job is, because obviously he can't do it himself, right? So he has agencies and department heads and all this other stuff. And so the executive orders are instructions to the executive branch on how to carry out their duties. And their duties are typically either proclamations or executing the laws of the United States or things that are associated with that, and foreign affairs and so on and so forth. So, therefore, we have to ask a question now, where if it's not in the Constitution that the courts can dictate to a president how he carries out the duties of his office, then where's the law? Well, first of all, how he carries out the duties of his office is authorities granted to him by the Constitution. All executive powers are vested in the president. So a law could not change it. A law cannot say, oh, by the way, you can't do this or you can do this or whatever. Typically, there are some gray areas on that we've seen in the legal system. I'm not going to get into that. And once again, the questions on whether or not those are actually constitutional, we can have that debate. But anyway, so then the question is, okay, well, the courts are doing that anyway. They are ruling on his executive orders. They are ruling on his actions and his memos and his letters and what he has done or what he has said. Can they do that? And if they can't, and whether or not they can rule on it, can they enforce it against him? Is the president required? The court says, hey, you can't do that. Is the president of the United States required to follow that instruction? When the court says, So I'm going to use two, because the enemies of the Constitution and of liberty and of, Donald Trump, this group says that the rule of law is the courts. Now, it isn't. The rule of law is the laws of nature, and of nature is God, and it's self-evident, but nonetheless, since the rule of law is the courts, and the courts are so important, we have to ask, well, is there any precedent then in the courts that says that the judicial branch can dictate to the president? Yes and no. There are examples of them dictating to him and the president folding. But was there actually a judicial decision that says, if the courts say you must stop or you must do something, you must, Mr. President? Not necessarily. No, it doesn't exist. Okay, well, how about the relationship between the president and the courts? Are there precedent? Does precedent exist regarding that relationship where the court said do it and the president did it? There's all kinds of that recently, 20th century on. Well, what about the founding era and the 19th century and the 18th century? Because that precedent would override any precedent afterwards because they are closer to the Constitution, right? And the way typically the left works is the oldest precedent is usually the precedent supposed to be followed. They're willing to overturn precedent on rare occasions, but for the most part, you will go back as far as you can to find a precedent that's closest to the Constitution and then go from there. Well, we have two, Thomas Jefferson and Andrew Jackson. So the case that basically established judicial review is called Marbury versus Madison, 1803. And the short end of the story is that William Marbury had been nominated and confirmed by the Senate to be a judge, a justice of the peace judge in Washington, D.C. It was based on a 1801 judicial act that was basically put in place in order to make sure that the Federalist Party didn't lose any power, lose all their power, because they had lost the White House and both houses of Congress. And so, as Thomas Jefferson stated, they retreated to the stronghold of the courts where it'd be more difficult to dislodge them. So the Judicial Act of 1801 had created all these new judicial opinions so they could load them up with a bunch of Federalist Party judges, which was big government Hamiltonian minded judges. Alexander Hamilton, following John Adams was president. And it's called midnight judges, if you want to look it up, because it is said that John Adams was up past midnight before inauguration signing the commissions. Now, in order for a judge or an officer to take their office officially, they have to receive their commission. So you get nominated, you're confirmed by the Senate, then the president then signs the commission, gives it to the Secretary of State. Secretary of State delivers that commission to you, and voila, there's your golden ticket. You are now a judge or an officer or whatever. Not all of the commissions were delivered. And so when President Jefferson took office and his new Secretary of State, James Madison, Marbury versus Madison, had this stack of commissions, he says, hey, what do I do with these commissions? And Jefferson said, don't deliver them. They're probably unconstitutional. The Judicial Act of 1801 was then reversed. It was repealed by Congress, and he signed it. But a lot of these positions stayed because part of it was turning Washington, D.C. into 2 counties. There was all kinds of different things going on, which they eventually did reverse also. And there's a longer story there. But ultimately, William Marbury, who says, no, I was nominated, I was confirmed, I was due my commission. You're supposed to give me my commission. And so he sued and went to the courts. And in the courts, it worked all the way up to the United States Supreme Court, and John Marshall was Chief Justice. And the court ruled, it was a split decision if I remember properly, but they ruled in favor of Marbury. Yes, you should have gotten your commission. Now, in his judicial opinion, John Marshall also adds that the idea of judicial review and that the courts, the judges take an oath of the Constitution, so it's their responsibility, and that's a different video for a different time. So let's focus on the fact that Marbury won. William Marbury won, and so John Marshall in court said, yes, Mr. Marbury, William Marbury, you should have gotten your commission, and James Madison should have delivered your commission, and the president should have instructed him to deliver your commission. At that point, however, the court did not order the president to deliver the commission. At that point, they did not order Madison to deliver the commission. because the courts don't have an enforcement arm. The enforcement arm of the federal government is the President of the United States, and it was the President who was saying you're not getting your commission. So you win, but good luck in getting your commission, because the guy who's supposed to give it to you is the one, the one to enforce this is the one who refused to give it to you. And we have no enforcement arm. We cannot dictate to the president to do it. This is the third president of the United States. This is precedent that's very close to the Constitution. And John Marshall is a hero to the left, creating judicial review and things like that. He spent 35, 36 years as Chief Justice of the United States, building upon federal supremacy, building upon this idea of bigger government and all that. But yet, even at that time, he understood a very important truth. The courts had no enforcement power. They could not dictate to the president what he could or could not do in relation to his executive branch. The next precedent, Andrew Jackson. Andrew Jackson was receiving word from Georgia and parts of Mississippi and northern Florida and all that area that the states wanted to develop. They wanted to spread their population, but the Indians were in the way, and they wanted the Indians relocated. And at that time, you were seeing the Indian populations being relocated west of the Mississippi River. And what ensued was ultimately known as the Trail of Tears. Not condoning the action. If you read the details about the Trail of Tears and what happened, it was pretty messed up. This video is not about that. It's about the legalities involved in this. So there was a lawsuit, went all the way to the Supreme Court. Supreme Court said, Andrew Jackson, you cannot relocate the Indians. It is unconstitutional. Andrew Jackson's response was, John Marshall, who, by the way, was still Chief Justice at that time, but instead of the beginning of his tenure, he was near the end of his tenure. And Andrew Jackson says, John Marshall has made his decision. Now let's see him enforce it. Let him enforce it. And then John Marshall conducted the Trail of Tears protocol of transferring those Indian populations west of the Mississippi anyway. And the courts did nothing about it. There were no lawsuits. There was nobody that said that stopped the president. Why? Because, once again, the courts had no authority to dictate to the president how he carried out the law or how he carried out the provisions of his office. He is in charge of the executive branch, being the president. And therefore, the president can carry out the duties of the executive branch. And he doesn't have to get permission from Congress or the courts. Now, Doug, you're saying the president can act tyrannically. Yes. But if he does, and it's beyond the pale, then guess what? Then Congress can impeach him and remove him for being tyrannical. So there is a check against bad behavior. But here's the thing. When Jefferson was told by the courts that his Secretary of State was supposed to deliver the commission to William Marbury, and when Andrew Jackson refused to comply with the courts and told the courts, see, enforce it. There was nothing that stopped them. There was no lawsuit. There was no impeachment hearing. There was, the matter of fact, there wasn't even, Congress didn't even attempt an impeachment. In fact, the first time that Congress ever filed articles of impeachment wasn't until John Tyler many years later. It wasn't even a thought to try to impeach Andrew Jackson for defying the courts. And it wasn't even a thought to impeach Jefferson for defying the courts. Why? Because they all understood that the executive branch belongs to the president. And if the people don't like what he's doing, or the electors, depending on which area you're talking about, then he won't be president the next term. Or the people and or electors will elect someone different next time that won't defy the courts. Because the ultimate arbiters, the final arbiters, are the people in the states at that time and should be still today. So, our first deal here is, does the courts have the authority to force the president to abide by their rulings? No. They cannot force him. They have no enforcement on him. If he wants to do it anyway, that's his business. If Congress says, whoa, you're going too far, they can impeach him. If the people are going, whoa, went too far, word will get out. They'll contact their Congress critters and they'll impeach him. If they don't, then he continues to serve as president. And then when his 4 years is up, then someone else gets to take the mantle or he gets reelected or whatever. Of course, in this case, Trump can't because it's second term, but that's another discussion. So, item number one when it comes to federal courts versus the U.S. president is the courts cannot force the president to abide by their wishes constitutionally. There's no constitutional authority in the Constitution, and early precedent says no, courts can't dictate to the president. The fact that we've had a bunch of presidents that have bowed down to the courts since then is due to this idea that the courts are the strongest branch and they can dictate and they're the final arbiters and all that. But if you go back to the founding fathers, originally the judicial branch was the weakest of the branches. In fact, John Jay, who was offered the Chief Justice position during the tail end of John Adams' presidency and had already served as the first Chief Justice, two others had served since he had left to become governor of New York, and he's offered it again, and he says, hey, in its present state, in its present form, it's beneath the man. There's no power. I don't want it because it's the weakest branch in the government. They've got no power. They just apply the law to the cases they hear, which is what was intended. All right, so now we got that all going on. And now we look at the things that they're going after Trump on. So the first one is federal spending. And then there was a federal spending freeze. Well, you have to spend that money. You can't freeze the federal spending on this or that or aid or this department. All right, well, what's the argument? Well, because Congress appropriated it that way. You have to spend it because of the appropriations. So if I gave you $20 and you're my child, go buy a carton of eggs for $20. You have to. That's because I portioned it that way, appropriated it that way. You come back, well, Dad, I found eggs for $9 for a carton and $7 a carton. I got the ones for $7. Then would my appropriate response be no? I gave you $20. You're going to spend $20 a carton, take those eggs back, go find someone that sells a carton of eggs for $20. Otherwise, you're disobeying me. No, that's ridiculous. Gave him the money to go buy the eggs. He then, in the real world instance, goes, whoa, the person who gave me the money gave me too much. I am going to then spend as appropriate. And then bought the eggs for later, brings back the change. That's the way it is with the president. The money is appropriated for, say, national defense. He says, okay, we're going to put this on this. Oh, look, we don't have to spend $5,000 a bolt and ridiculous amounts. Let's reduce, let's make it cost less because I'm the executive, I'm the guy with the money now, and I'm in the real world situation, and I'm realizing that's too much money or this is wasteful, so I'm going to spend it as I believe is best for the country. Look, I saved us money. This is going back to the Treasury. What is happening is then now they're suing and say, no, you have to spend the whole amount on what we told you to spend it on. You buy the $20 carton of eggs or we're going to go after you legally. That's ridiculous. President, now that power I just talked about where the president decides on how the money's going to be spent and how much and all that, that's called the power of impoundment. And the presidential power of impoundment is a presidential power recognized going all the way back to, well, Thomas Jefferson. We got Jefferson again. And in his case, it was a couple times. First of all, when he became president, there was a lot of expenditures under the John Adams administration he decided was excessive and it was wrong, and he didn't spend it. Money went back to the Treasury. And then when it came to the Mississippi River, Congress had appropriated funds for an increase of naval presence in the Gulf and the Mississippi River because our western edge of our country at the time was the Mississippi River. So the east bank of the Mississippi River was United States territory. The West Bank was France, and New Orleans, Spain, then went back to France. It was France and went to Spain, and they came back to France, and that's a different story. And so, and what was happening is, Mississippi River, that's an important trade route to get goods up and down, supply route, right? Get goods up and down to the west side of the United States. But you've got French resistance and Spanish resistance. Spanish is like, you can't even use the New Orleans port. So how can we send goods up the supply chain, up the river to our western side of our country if we're not even allowed to use the river that really is half ours? So Congress is like, hey, let's increase naval power. Let's make sure that we can use that port, get through that port, and then patrol it so that we're not being kept from using that supply route. And the money was appropriated. Then shortly after that, James Monroe and Livingston went to France and to Napoleon, because now New Orleans went from Spain back to France. So France had New Orleans and the western side of the Mississippi River heading out towards the Pacific Ocean. And so Jefferson sent Monroe and Livingston to France to negotiate with Napoleon on purchasing New Orleans. They weren't even there for the Louisiana Territory, just New Orleans. Say, hey, we need access without problems. Hey, you sell it to us, we'll give you access to whatever. Napoleon, meanwhile, is at war with the rest of Europe at the time. And he's like, well, you know what? I've got all this property out there that I can't defend. We're not colonizing it. And I need the money for my war. Tell you what, for $15 million, I'll give you New Orleans and the Louisiana Territory. So through via treaty, to make sure it was constitutional, Article 6, all sort of stuff, the Louisiana Purchase happened. And now we have the Louisiana Territory, so we have the west side of the Mississippi River also, and the entrance there at New Orleans. Suddenly, the appropriation of money for the increased naval presence is no longer necessary. We no longer need a strong naval presence because now we own the property. Therefore, Jefferson then could send back those monies back to the Treasury. Presidential power of impoundment. He didn't have to spend it. It was not necessary. He chose that. Congress didn't go, no. We told you got to spend that money on the military. You got to do it. No, because it was his power. And presidents throughout history did that. President Johnson, President Roosevelt, both Roosevelts, Wilson, Democrats, Republicans alike, used the presidential power of impoundment. And then in 1974, because they were ticked off at Nixon, because Nixon kept refusing to spend money on certain things, and they hung the Watergate over his head, say, hey, sign this law that takes away your presidential power of impoundment, and we won't impeach you. Talk about dirty politics. And so the law was passed. He signed it. And the law in 1974 took away from the president, according to that law, the presidential power of impeachment without approval from Congress. Now, we have to ask ourselves, if it was recognized as a constitutional power, the president has that power based on his position as having the executive power vested in him. It's irrevocable, it's exclusionary, and it's given to him by the Constitution. Can Congress use a law to take that power away? No, that'd be unconstitutional. Therefore, that 1974 law is null and void. It's an unconstitutional law. Or as John Marshall would say, a law that, contrary to the Constitution, is not a law. So now you've got an unconstitutional law, and you got a presidential power of impoundment that's always existed. So does the president have the authority to freeze federal funding, to set it aside, to look into it, to read and all that? Absolutely. So the courts are wrong here. All right, so then we get to the federal workforce, federal law enforcement, federal prisons. And this comes down to, how to, if to fire people, what to do with the personnel, how to arrange things, who to put in different positions. Executive branch, it's his branch. He's the CEO, basically, of the executive branch. He's a guy in charge. They serve at his pleasure. He can fire them. They work for the executive branch. And if he decides you're no longer going to have a job, you have to come to work, we're going to send out an email to make sure you guys are alive. You have to answer the email. That's all the executive's business, because it's his executive branch. He doesn't, going back to now the first thing I was talking about with the courts, he doesn't have to ask the courts for permission on running the executive branch. And they don't have the power to enforce their contrary opinions. It's up to him. Then we have birthright citizenship. Birthright citizenship is an interesting one. Trump has basically said birthright citizenship is being misdefined. We have illegal aliens making babies, leaving them on American soil, and they're not automatically citizens. And he got sued for it. Well, you can't do that because, you're going against, you're violating the rule of law. Okay, so show me the law that says if someone's born on American soil, they're automatically a citizen. Believe it or not, no law exists. There's never been a law made that says that. All right, how about judicial precedent? Show me judicial precedent that shows that if someone is born on American soil, they're automatically a citizen. The enemies of the Constitution, the left, whoever you want to talk about, what they'll come up with is 1898 United States versus Wong Kim Ark. The Wong Kim Ark case is used as the foundation of birthright citizenship. Because of that case, if you're born on American soil, you're automatically a citizen. The court said so, except for that's not what the court said. If you read the ruling and you read the judicial opinions, what you find is, no, that's not what they said. They said that he was born on American soil, and because his parents were permanent residents, he's a citizen. So there was a second requirement that was met. Permanent residency was needed in addition to him being born on American soil. They needed to have gone through some type of immigration process to show allegiance to the United States, in other words. Well, why would they do that? Now we go to the citizenship clause. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. And means it's a second requirement. So we have to ask ourselves, what does subject to the jurisdiction thereof mean? And in modern times, they've defined it as being, within the borders and subject to the laws. Well, there is no law that says that simply being born on American soil is enough. And the Constitution says, and subject to the jurisdiction thereof. There's no law that says subject to jurisdiction thereof only means within the borders and subject to the law. And we have one court case which says subject to the jurisdiction was met with the permanent residency. Born and subject to the jurisdiction thereof. Met. When someone gives an oath to the United States as a naturalized citizen, naturalized or born in the United States and subject to jurisdiction thereof. That's subject to jurisdiction thereof. That's the reason why in the oath they have to renounce their prior citizenship to any other country. If you've ever been to one of these ceremonies, you'll see that. My wife went through that in 2007. Gave the oath. She's an immigrant. So she had to renounce her citizenship, ironically, considering what we're talking about, to Mexico, in order to satisfy the and subject to the jurisdiction thereof part. Okay, so then where is this whole legal thing coming from? And why does Trump think that it means what it means, that he can do away with the birthright citizenship of an illegal alien? Because of the original intent of that clause. See, the Constitution was written in committees, the amendments and the original articles. In this case, the guys who ran the committee and basically wrote the citizenship clause, a Senator Trumbull and a Senator Howard, and this is in my first book way back in 2014, 25 Myths in the United States Constitution, if you want to read about it. And it's a couple of my other books, but that's the book where I really first get into the nitty-gritty of it. So, I've been talking about this since 2014, actually further back, but I wrote a book with this in 2014, so don't think I'm just suddenly coming up with this. Anyway, so when they wrote this, because it was a committee, they still got to go before Congress to explain what they wrote and answer questions in a basically like a congressional hearing. And they give congressional testimony as to what they meant. And it's in writing in the congressional record. It's called the Congressional Globe. May 30th, and in their testimony, Howard's on May 30th, 1866, to me, once again, is the Big one. It says, hey, what we mean is full jurisdiction, meaning full allegiance. Getting back to the, renouncing your former citizenship, permanent residency of the parents, because a child, when they're born, isn't able to determine their allegiance, but the parents were doing what they could, because Chinese back then could not become citizens, so they became permanent residents. So they're trying to satisfy and subject to the jurisdiction thereof for citizenship of the child, or at least that's what the court said. So, and full jurisdiction, it's full jurisdiction. Full jurisdiction. Well, you say, well, jurisdiction of the laws. They're fall under the law. Well, do illegal immigrants fall under all of the laws? No, then it's not full jurisdiction. It's partial jurisdiction. But they said we mean full jurisdiction and then full allegiance. So if that means full allegiance, the child can't make that call. Then what do you mean? They were asked. And Howard and Trumbull, both in different testimonies, said the same. We mean that the Indians not taxed and the children of aliens, foreigners, diplomats, and ambassadors are not eligible automatically. They got to go through the process. They're not just suddenly American citizens who are born on the soil. The language for that came out of an 1866 law, Civil Rights Act of 1866. They were almost verbatim using that language. So remember, I asked earlier, is there a law that says born on American soil alone makes you a citizen? And I said no. Is there a law that says born on American soil and having allegiance to the United States, is that in law? Yes. The Civil Rights Act of 1866. So the definition that Trump is using is founded in congressional testimony by Trumbull and Howard and a law. His job is to execute the laws of the Union, laws of the United States. And there's a law, the Civil Rights Act, of 1866. There's been other laws that have kind of echoed it, but that's the big one. So he's executing law that's on the books that says, hey, if you, in order to be a citizen, you must have allegiance, must be subject to the jurisdiction thereof, and the children of foreigners and aliens who have allegiance elsewhere are exempt from that. He is doing his job as president. He is executing the law. So birthright citizenship, he's right in his definition. Well, yeah, but Doug, he's changed the definition. It's been held. Well, that definition is wrong. There's a law and there is congressional testimony that says otherwise against birthright citizenship just being born on American soil. President Trump is right on that one. And then finally, DOGE. Should Elon Musk and DOGE have access to federal records? Should they be able to audit the government? Is that constitutional? Well, he's an unelected individual. Well, Fauci was unelected, and look at what he did. Right? So the question is, does the president have the authority to audit how money is being spent and then eliminate wasteful or fraudulent spending? Well, we already kind of took care of that with the first one, federal spending, right? He has the presidential power of impoundment. Plus, he has an agent he's brought in as an auditor. Elon Musk has no power. He's not even being paid. He's doing this on his own dime. All he's doing is auditing. If a company was spending money in a fraudulent manner or a wasteful manner, and the government said, hey, you need to be audited, we think you're breaking the law, are they going to say, okay, government, audit yourself from the very inside with people that are part of the government? No. They're going to bring in an outside auditor. That's what Elon Musk is. He's an outside guy. He's not a part of the government. He's not receiving a paycheck from them. He's got no ties to it. So it's not going to be in his best interest to find government not guilty. So here what we have is an auditor that's being brought in to root out waste and fraud, and now the president's being told, well, you can't do that. So if a president of a company wanted to bring in an outside auditor to make sure the books were okay, Would that be unlawful? Would that be wrong? No. What's the difference? The President of the United States saying, hey, I want to carry out my duties as president the best I can, and I believe there are problems, and I want someone from the outside to come in, find those problems so we can then deal with them. Totally constitutional, totally okay. And it ties into all the other things, presidential power of impoundment, and the fact that the courts can't dictate to the president. So there you go. So now the ultimate question, federal courts versus U.S. president. Can the courts dictate to the president how he runs his branch? No. Can they force him to spend the money the way it was being spent, or force him to unfreeze a federal No. Can they force him to carry out the law regarding birthright citizenship in a manner that opposes the law? No. The law says if you're born on American soil and subject to the jurisdiction thereof, then you're a citizen. But if you're not subject to jurisdiction thereof, you have other allegiances, you don't satisfy both parts of that clause. The Civil Rights Act of 1866 says so. And they're telling him, no, President, you can't follow the law. You have to do it the way we tell you because tradition says born on American soil is good enough. Even though there's nothing on the books, in the law, or in the courts, well, except for we think it's, the Long Kim Mark case, but don't read the whole thing because we're actually lying to you. U.S. President wins. Thanks for spending the time. We'll see you next time.